Guys, I'm really excited. We'll be doing this, a year and a half now? I think in or around there. Something happened today for the first time that has ever happened at the Somewhat Tipsy studio. Jimmy, I don't even know if you realized it. Jeremy beat us to the studio today. He was the first one here.
Y'all need to catch up. I'm starting to be on time now.
Last one here. How would I realize that?
First time ever.
In a year and a half that I was the first one here. I'm going to need y'all to step up your game in 2026.
From one time.
One time.
It only takes one time, all right? I'm turning over a new leaf.
All the employees at all of Jeremy's restaurants, remember, it only takes one time to turn over a new leaf.
Well, it's your last day.
Well, we got a good show today.
I'm excited. Something slightly different than we normally do. You know, we're going to go outside the restaurant, but something that you don't think about, something that's important and you don't ever really need it, or it doesn't come to your attention until you need it.
Well.
So let's welcome Jason Harr to the show.
Hey, thank you for having me.
Thanks for coming in.
Like, awesome. I'm so appreciative of you guys inviting me.
Yeah, we appreciate you coming on. It's there's been a lot going on. I mean, you know, when you talk about law, there's so much that you could talk about.
We should probably say he's a lawyer too.
Oh yeah, they don't know that yet, do they?
Say the lawyer part.
Terrible introduction, Jeremy.
Yeah, you know what? I'm on time. That's all we're going to worry about. Okay.
Yes, I'm an attorney with the Harr Law Firm in Daytona Beach. We have our own office building called the Harr Professional Center because I couldn't come up with a more creative name.
Professional Center is very professional.
I just couldn't. And we're just a few blocks south of City Hall in Daytona Beach, right there, centrally located for everybody.
All right. Now, how long have you been in law and in Daytona?
Well, I've been an attorney for a quarter of a century, as it shows on my face. But the Harr Law Firm has been in existence. We just started our 22nd year.
Oh, wow. Congrats.
Thank you so much. I really appreciate it. I grew up here. I went to elementary school, Father Lopez High School. You know, really enjoyed it.
Do a lot of lawyers join, or do a lot of lawyers try to go on their own? I mean, I know it's a very open-ended question, but you hear like, oh, I'm going to join this, you know, let's give you an example. I'm going to join Morgan & Morgan. Right. Well, you're one of 800 lawyers. And then a lot of people go on their own. Is it a decision, or when you get out of law school, is it like, hey, come join me, I'll pay you what you want, or hey, let's start our own together with my friend or by myself?
It's particularly around here, it's sort of all of the above. Obviously, when I got started here, there really wasn't a Morgan & Morgan branch in Daytona like there is now. They're on Seabreeze. Or Fair. They're here too, right off Bevel, or on Bevel Road.
But you're local, obviously. You've been here, you grew up here, you know.
And so people knew me and they trusted me. And I was working for another lawyer, and a lot of people came up to me and said, look, Jason, I've known you your whole life, and if you open up your own law firm, I promise we'll hire you. And I was like, oh.
Because they didn't want to go with I don't say a big law firm at the time. They wanted more they
wanted somebody they knew they could trust and wouldn't rip them off.
Gotcha.
Plus they were like, he's young, he's hungry, he'll probably put in 10 hours on a 2-hour job, which is what I did. Which
we all do. When you start a restaurant, you do the same thing. When you start anything, you're there 300 hours for a 2-hour pay.
If you want to be successful,
but that's what it all does.
And it just took off. It just really did. It took off right from the very beginning. And I was very fortunate that it worked out the way that it did. But you have to, you know, for someone like me, I mean, I went to graduate business school before going to law school because I knew I had to learn accounting, marketing, finance, and all these other things that help you run a business, because half of what I spend my day doing is running a business. It's not necessarily being an attorney, but that's what comes with the territory. There's just a group of lawyers who want no part of that, which I can completely understand. They just want to practice law.
These lawyers run a business, not even law.
They don't want to run a business, which I can accept just fine. You know, I think that's great. And, you know, hopefully they find themselves in a happy place where they're treated fairly. It's just, that wasn't something, I wanted to be able to provide a level of service to the local community here in Volusia that I believed, and I was being told they weren't getting. They were like, well, I pay my attorney a bunch of money and then 3 months go by and all I get is a bill.
Yeah.
And I said, well, we're going to do things entirely differently. and we're going to be upfront with what we charge so that when you get something from our office, it's work. It's not a bill, an invoice. And we're just going to focus on getting you in the best shape that you can out of your legal situation. And it just took off from there. And to be honest with you, I mean, despite taking marketing, that was back in, I graduated that school in 1996 at the University of Miami for grad school.
Cocaine.
Yeah, absolutely.
How about them Gators, though?
You know what?
They hired my coach from my undergrad school, John Summerall from Tulane. We're all walking around now in these T-shirts that say RMFW, which I will not say on the air. We just lost our head coach to Florida, which is sad, but
it's great to be a Florida Gator.
I wish him luck. I wish him luck. I mean, the guy's got 4 years of head coaching experience, 2 at Troy and 2 at Tulane, and he's going to have to deal with Kirby Smart and Kalen DeBoer and now Lane Kiffin at LSU, and
that shocked me.
And Texas A&M, who are really, really good.
Lane Kiffin, I get why they won't let him coach the playoffs and all that. I get that because he's left for another school. But Ole Miss, this is the best they've ever done. He has brought that school to a different level. And I respect the fact that he didn't do it for his personal money.
Yeah.
And this is what I hate about what is happening to college football is that he went because that school is going to pay the players more. I hate that about college football. It is ruining the game.
I don't think they should be paid at all.
No,
I don't. No, I think we should go back to the day. I'm sorry. I like the days when I was in college. Nobody got paid. No one was allowed to take money.
Oh, they got paid.
But everyone did. But it was under the table and this and that. But it wasn't. Now they're getting endorsement deals. Now these college kids are making $8 million in college, and you don't play the same.
See,
you don't care.
I have no problem with them getting paid. I hate the transfer portal.
How about a salary cap? How about a salary cap then? How about a salary cap?
Oh,
every player should be capped out.
I don't think freshmen or seniors out of high school, so freshmen, I don't think freshmen should be paid. I don't think they should see a dime. I think they should have to pick their school on the school's merit. I think after your freshman year, you can start getting paid.
You can recruit.
And the transfer portal has to stay like it used to, where you had to be leaving for educational purposes. I miss that about college football.
See, you went to a school because you wanted to go there and had a good education program. Now you go to school because they're going to give you $80,000, $150,000 to play there.
$80 million. Well, not
you know
$8 million.
And that's what happened to my undergrad, which is Tulane University in New Orleans. I mean, we had a quarterback named Darren Menso last year, who's a pretty good quarterback. He ends up transferring to Duke because they're willing to pay him for his last 2 seasons $4 million. Well, Duke comes to New Orleans to play us just by coincidence. And Tulane won that game very easily.
Yeah.
So how did it feel to pay our former quarterback $4 million just to come down to New Orleans and show you how we do things down in New Orleans? So we felt pretty good about that. That's for sure. We were very happy about that. Yeah. But I tend to agree with you both. I liked the amateur days. I really did.
You look forward to going to the NFL.
And I don't understand the idea of paying an 18-year-old like that.
No.
It's a 21, 22-year-old I don't think should be getting paid $8 million.
I don't think it should either.
I'm not going to school for $8 million. I'm going to do just the bare minimum so I can get my $8 million, my $4 million this year. I'm going to party. I'm going to buy the new car I want.
Yeah.
Everyone was always getting paid. I mean, they've been getting paid since the beginning.
But
it's not millions, but you were getting really
your
nice
mom
cars.
Got a new Mercedes.
Your parents were getting houses.
But I was okay with that.
4- and 5-star recruits were getting paid, but they weren't getting the type of money that they're getting now. And I think because they don't teach finance in high school. They don't. They teach you nothing about finance. No reason you should give a kid that much money without any education on what to do with it.
I agree.
It blows my mind.
And they used to, like in the NFL, when you're a rookie, they actually have former players teach you, look, this is who you can trust your money with. This is who you can't trust your money with, to help them from getting ripped off. In college, I don't really think that system is in place yet to protect the players.
It's not.
And so they're at great risk from people who would try to steal their money, and that's terrible.
And what do they say? It's your family and your friends that'll rip you off most of the time before it is anybody else. It's a shame. But I don't think we came to talk about the education system today.
He just got way off track.
And we're probably the wrong guys to ask that to.
Yeah. But I did want to talk because there's, a lot of stuff going on in the hospitality world right now, especially in our area locally. I don't know if it's really spread further in the country, but in the Volusia County area, there's been a lot of lawsuits and a lot of businesses closing. Yes. There's been lawsuits about it being ADA compliant.
And ADA stands for what?
American Disability Act.
Correct.
Yeah. So a lot of these places can't afford the payouts. They can't afford the repairs. They can't afford to fight this fight, and they end up shutting their doors.
Yes.
And then the ones that do settle and they find the money and they do all this, they get sued again, and they're struggling. They can't even, pay their bills like they used to because they're broke at this point. They're still paying attorney fees. They're paying all this. And, we really wanted to bring you on today because, the experience that you have. And I think you could shed a lot of light and knowledge so everyone kind of knows what's going on, because everyone has an opinion. Facebook heroes, they always have an opinion. But I think what I see the most and all the comments and everything, no one really knows why this is happening or how.
Well, let me start out by just giving you a brief history. When I did open up 22 years ago, I knew there was no point in trying to compete with the bigger law firms for that type of work. Fortunately, for the few years that I worked at another law firm, I'd spent a lot of time in federal court. So I was very experienced in federal causes of action, which of course the ADA follows under. It's a federal law. And what it basically says is, you cannot discriminate against somebody due to their disability, be it, developmental disability or physical disability. And so it really kind of started in South Florida, where some bright lawyers came up with this idea. And strangely enough, as part of these lawsuits, the plaintiff themselves are not allowed to make any money. All they can do is force the business to make the changes. Then the business is meant to not only pay their lawyer, but now they have to pay the plaintiff lawyer if they settle the case. Well, the phenomenon that came along with that, where some businesses were like, well, maybe I'll just skip paying two attorneys. I'll just pay the plaintiff attorney and not pay an attorney to defend my business. Because in federal court, if you are a business, you 100% of the time must be represented by a licensed attorney. That's it. There's no exceptions. Like in small claims court and state court, a layperson can represent a business.
Yeah.
That's no problem. Federal court, the exact opposite. So then what happened were these people started making these settlement deals with the plaintiff attorney. But part of the deal included that they were going to have to make all of the changes. So they were 100% ADA compliant, which is not what the Americans with Disabilities Act requires. The Americans with Disabilities Act requires a business to make changes which are readily achievable. You do not have to bankrupt your business by, if you're a small, restaurant, your breakfast, you serve breakfast in the morning, maybe lunch. You don't have to spend the same amount of money that Walmart would have to spend under the Americans with Disabilities Act to become compliant. But now you've agreed to a settlement with an attorney where you have agreed to make all of the changes and become entirely ADA compliant as if you were Walmart, which means, for instance, if your bathroom doesn't have enough space for a wheelchair to circle, then guess what? You're going to take down some load-bearing walls. You're going to hire a general contractor, an engineer, an architect, and you're going to spend hundreds of thousands of dollars. And if you don't, you have now breached the contract that you made with the plaintiff attorney, which means that plaintiff attorney can now file a motion with the federal court, which is in Orlando. The closest one's in Orlando. There's another one in Jacksonville. And then you get to go in there and explain to a federal judge why you're violating an agreement you voluntarily entered into. And by the way, you have to hire a lawyer to go there and represent you, and good luck with that. There are not too many lawyers jumping at the chance to want to go try to explain to a federal judge, or any judge for that matter, why a settlement got breached by their client.
Yeah.
There's no winning argument there. And so that's what I see a lot of. In fact, recently we went down to New Smyrna Beach and spoke with about 20 different business owners. And after I did just a real quick introduction, hi, I'm Jason Harr, the Harr Law Firm. My office is in Daytona Beach and all that. I asked for a show of hands, almost as if we were in a classroom. I said, how many people have been sued for ADA violations? And these are all small mom and pop businesses, local businesses, like my business. And a bunch of them raised their hands. I said, how many of you have settled? Almost every single one of them raised their hands. I said, how many of you got sued again for the same exact thing? They all raised their hand. And that is the problem, because what the settlement agreement typically says is you agree to make all of the changes, no matter how much it costs. No matter how much it costs, you agree to make all these changes within a 12 to 18 month period. Well, that 12 to 18 month period, while you may think, well, gee, that gives me enough time to raise the money and do what I need to do to make all of the changes. No, what it does is it gives other lawyers the opportunity to sue you, particularly when they look on the public record and see that, a lawsuit got filed and now there's a notice of settlement, because it's all public record anyway.
So they can sue for the same thing?
No, what they do is your business, if the first lawyer will give you 12 to 18 months, it'll say in the settlement agreement, to become entirely ADA compliant, as if you were Walmart or Amazon or Publix.
So you had to pay your lawyer for doing it. You had to pay their lawyer, and then you have to agree for in 12 to 18 months, I will make all these changes in here.
So while the 12 months, you're taking the 12 to 18 months to make the changes, you're still not ADA compliant. Other lawyers, plaintiffs' lawyers, have seen, oh, wow, look, all this lawyer did was file a lawsuit and they paid all this money to the lawyer. So there's a reason for the 12 to 18 months. It gives other lawyers an opportunity to get in there and sue you again before you've made 100% of the changes.
And there's no grace period when you do that first settlement for 18 months. There's no you're not allowed to sue anything.
No, because you can't stop another lawyer from suing.
Yeah. Huh.
I mean, these are, when you sue in federal court, it's a public record.
Yeah.
It's not like in state court, like if it's involving a child, like a DCF case where it's entirely sealed and nobody can know about it.
You can just go type in and be like, who got sued for this?
Yeah, wow. And then
here's
you can
a list
look
of 30 people and just go send right there.
And you just look at the docket. The complaint got filed. Some lawyer, defense attorney got hired to answer the complaint instead of filing a motion to dismiss, because most of these plaintiffs don't even have standing, which you have to have it's kind of a legal concept. You actually have standing to appear in federal court. There has to be some nexus which allows you, between the two, the plaintiff and the defendant. For instance, we represented a bar in Longwood, Florida, that had heard of us. And there was no special service. I mean, there were wonderful people, but there was no there was no difference between this bar, which was 45 miles away from where the plaintiff lived. So the plaintiff was making a 90-mile drive. Well, guess what? Under those terms, that plaintiff did not have standing to be in federal court. We file a motion to dismiss. We send a letter to the attorney saying we're going to seek reimbursement of attorney's fees and costs. And the day the lawyer gets the letter, the lawsuit was voluntarily dismissed.
Huh.
Because, for instance, we got contacted by someone out in Orlando this week. That plaintiff doesn't have standing to bring that lawsuit. Yet what's happening is people are settling these lawsuits, and it's just taking a bad situation in many ways, making it a lot worse.
Now, my question is, why would their lawyer allow this if they tell them, hey, you're getting sued, go ahead and sign here, give me $5,000, give him $1,000, and it's going to go away for 12 days, but you got to fix everything. What lawyer would tell them this is the right thing to do?
There are plenty of lawyers that are out there doing it.
I don't know why. It's not the right thing to do, obviously, because you're going to get sued again, and you have to correct that $100,000, $200,000, $300,000 job in 18 months. Like, Who would advise to do that? Hey, I bet your best interest is to go ahead and sign this. Give me my 5, give him his 5, whatever. I'm making up the number. And let's just go away, and then 18 to 12 months we'll figure this out. Like,
it doesn't make any sense to me.
So what would you advise them? So if somebody came to you and said, hey, I got sued for ADA, I got this letter in the mail, this and this, what would you advise them to do?
Well, the first thing I would do is I'd learn a little bit about their business. And once I knew about their business, I can then, because I have, you can get a password so that you can go online and look up federal cases, just like you can state cases, because as I said, it's all public record. So then what I do is I go and I look it up and I see what the complaint says. And then when I see that the plaintiff lives 40 miles away from the business that the plaintiff is suing, I have to go back. I go back into the room and explain to the potential client, hey, look, you've done nothing wrong here because this particular person doesn't have standing to sue you. It's an 80-mile, for instance, that bar, there were probably 250 bars this plaintiff could have gone to between where the plaintiff lived and where my client ran their business, which means you don't have standing anymore. So we find, the legitimate legal defenses that allow us to file motions to dismiss or to get the lawyer who filed the case to voluntarily dismiss it. I mean, we had one where I just called the lawyer up and I said, it's me, Jason Harr. And that lawyer dropped the case. I didn't even get that far. And so, the problem is, I don't know how much experience some of these lawyers have with the Americans with Disabilities Act or what the legal requirements are for, in how they differ between small, businesses like those here in Volusia versus large corporations. Because what's readily achievable to Publix and Walmart is not readily achievable
to Joe's Sandwich Shop.
Exactly. And by the way, the Americans with Disabilities Act doesn't require a business to be 100% ADA compliant unless you are Publix or Walmart, in which you can spend $200,000, $300,000 to gut a building and it's a blip in your budget.
Yeah.
And what has to happen is the plaintiff attorney actually has to hire an expert to go into the business, to look at the business's finances and the changes that are being recommended by the plaintiff's ADA expert and be able to convince a judge, because in these ADA cases, there's no jury trial. The federal judge is the judge, jury, and decider who wins, who loses. And they have to be able to bring in an expert who can say that these changes that are being asked for are readily achievable for this size business with this. I mean, some of these businesses that got $5,000, $10,000, in the bank, you can't ask them to make $50,000 worth of changes to their building. And by the way, the Americans with Disabilities Act doesn't require them to do so. So it's a shame the way it's going right now, and I hate to see it. I really do, because I don't think, that when Congress passed the Americans with Disabilities Act, this is what they want.
No, but there's people that will find loopholes all the time.
Absolutely.
They'll find the loophole in the restaurant. We get that all the time. Comes in, 75% eating burger, and then, it's not cooked right, knowing they're going to get another one, knowing they're going to take it home.
Yeah.
They'll find a way to find a way, if that makes sense.
My question is, it sounds like the lawyers are making good money. They're
making excellent money.
They're doing well. What is the plaintiff getting out of this? How much is there a good amount of money that the plaintiff's getting too?
The plaintiff is not allowed under the Americans with Disabilities Act to be paid any of the proceeds from the case. All they can do, as I said, is what we call injunctive relief, which means the plaintiff, by virtue of being a plaintiff in this lawsuit, they can force you to make some of the changes which are readily achievable. Those are the magic words under the Americans with Disabilities Act.
Hey, you need to lower this. That's going to cost you $1,500.
For instance, to even qualify for the benefits of the Americans with Disabilities Act, you have to be able to convince a judge that your client is disabled. Half the complaints I see don't even describe how the client is disabled. Well, that's the first step of having a case under the Americans with Disabilities Act. It's not even in the complaint. And yet, the defense attorney's just treating it like, I guess they're disabled. I don't understand it. I just don't understand it. Because the plaintiff is always the one with the burden of proof in this type of case. It's not the defense's responsibility to get in there and say, look, we're ADA compliant. The plaintiff has the burden of proof, the initial burden of proof. And a lot of times they don't meet that burden of proof. They just don't. But, some of these settlements, they're just, I hate to see it because I know what's coming next. I know what's coming next.
It's another lawsuit, right?
And it's another lawsuit. And then a hearing in front of a federal judge to explain why you didn't make 100% of the changes that you voluntarily entered into a settlement agreement to
even
do.
Even if he doesn't agree to it, you agree that that's right. He still has to withhold that contract.
Yep.
I mean, I've had people call the office who signed these contracts who just said, obviously I can't mention names, who just said, well, I'm just going to violate the agreement because I can't afford to do what I agreed to do. And I said, you might not want to do that. I said, you might want to talk to lawyers who actually understand, who've spent most of their careers in federal court like I have, and find out what your options really are. Maybe they can go back to, the attorney that they made the deal with and say, look, these are the changes based on our budget that we're willing to make. I mean, some of these changes, for instance, putting up signs where the bathroom is or the exit sign in Braille, I mean, that's $10 on Amazon. That's readily achievable to anybody's business.
Yep.
So that has to be accomplished by, the mom and pop shop. But most of them are more than willing to do that anyways, because we've represented every type of business and defended them in these type of cases. And to a person, there's never been one who said, well, I don't want somebody who's disabled in my business.
No.
They said, most of them have said, it's the exact opposite. I want disabled people of all shapes, colors, races, genders, everything to come to my, this is a business. We're here to provide a service to everyone, not just a certain sect of people.
Yeah, I want them to be comfortable coming in. I want them to have, all the accessibility they can.
Absolutely. And I'll tell you, the new wave of these ADA lawsuits that we are now beginning to see involve businesses' websites. In other words, there are people based on visual impairment who use what's called reader software. And so under the Americans with Disabilities Act, everybody, regardless of their visual ability or not, should be able to peruse your website. And so that's what we're seeing now, is businesses which are ADA compliant in their physical location are now being sued because their website doesn't accommodate this one specific reader software. Meanwhile, there are tons of reader software on the internet. And so this is the next wave that's coming down the pike, and we're already beginning to see it. And once again, is it readily achievable? Can a business afford? Because there are plenty of website companies, unfortunately, that will tell you, oh, I can make your site ADA compliant. They don't know the first thing about what they're doing and how to make the ADA website compliant. You have to go with, a company that actually has somebody who is certified in the Americans. You can get certification as an ADA expert.
Yeah.
And that's who you need to go to, and that's who you need to talk to about websites, because that's the next thing. Once all the mom and pop shops have all been sued and there's no more money, then you're going to see many of them get sued for website issues. Wow. That's coming down the pike.
And why do they pick restaurants necessarily? Is it just easier, or why not pick a hair salon? You hear a lot of restaurants now are having these problems, or have had these problems for the last 10, 15 plus years. Why not the hair salons? Why not the grocery stores? Why not the gas stations? You hear mostly, it seems, restaurants.
The gas stations definitely get hit. And a lot of them, depending on, on the store that's in the middle of, in between the pumps, there are definitely, some pretty bad violations. But there are things that, in the system that the Harr Law Firm developed that we can help remedy all this, so that the business meets the requirements that are readily achievable under the ADA. But you're right. We're seeing a lot of restaurants. Frankly, it's my understanding that some of these plaintiffs, all they're doing is they're going on the internet and going on what's it called, Google Earth.
Yeah. Where they can view the actual
they can view your
entrance.
parking lot.
Yeah.
And once they see that the parking lot, isn't ADA compliant, boom.
Boom, they're going.
They're going for it. And one business, I had a business that called me up last week where in the complaint, because it's the same complaint that's used in all the cases, said that the bathroom didn't have grab bars. Well, that's just not true. The bathroom absolutely had grab bars. They just cut and paste a different business
And do the same thing.
and they do the same thing all over again. And I don't understand it. And unfortunately, a lot of times, initially, it may be cheaper to just call up the plaintiff attorney, not hire your own attorney and say, oh, this is the most I can afford to pay you. But in the long run, it'll cost you way more than it ever did once you've had to make all of the 100% of the changes than if you had hired, the Harr Law Firm, for instance, to come in there, file a motion to dismiss, get the case thrown out, or as happened in many of our cases, the plaintiff just voluntarily dismisses it because they don't want to fight.
No,
they don't want to fight
they
the
don't wanna
case.
go to court.
I mean, we've had, and I'm glad, Jeremy, you brought this up. We've had restaurants that have been sued where the person never entered the restaurant. And then they say that there are problems with the bathroom. Well, not only did they never enter the restaurant, they sure as heck didn't go in the bathroom. Yet they're describing the same list of problems with the windows the mirror, is too high. The towel rack isn't in the right place. There are no flappers on the sink. There's no padding. If you have a sink that a wheelchair fits under, which you need to have, of course, you have to have padding around the pipes.
Yep.
Because somebody with, who is in a wheelchair is not going to feel the fact that
if you hit it.
They're hitting the pipe and maybe cutting their legs open. So, there are things like that. We have a trusted ADA expert that the client does business with. I don't know how much she costs or anything of the sort.
No.
I don't get involved in that. She doesn't send me a thank you note, or all I get is a report saying, the business is ADA compliant. That's all I get in return. And no gift certificates even to, the restaurant that got sued.
Right. No gift certificate?
I think you should get some gift certificates.
Where's that buy one, get one free drink at least,
I mean, throw guys some fried mozzarella sticks once in a while.
Something.
But but that's the most important thing is, businesses are entering into settlements that they really shouldn't be entering into.
Yeah.
They just shouldn't. Congress knew what they were doing. There are mechanisms in place to protect small businesses in these kind of situations in terms of what they're expected to do and how they go about their business. And the ones who just quickly settle, it just, to me, they all have many things in common. And most of it is they get sued by another attorney within a month or two.
Yeah.
And so now the whole process starts all over again. Where if you just, and I understand hiring a skilled federal defense attorney. I mean, there's a reason they say don't make a federal case out of it. It's because what does that mean? Don't make a big deal. Federal cases are big deals.
Yeah.
Believe me. And they're to be taken extremely seriously. But, what I fear, and of course I'm not involved in these conversations, but what I fear is, people are being told or given advice that just really doesn't apply to their situation.
Yeah.
And that's most unfortunate. And I hate to see that. I really do.
Now, to practice ADA or to be able to practice that part law, do you have to have a special certificate, a special degree, a special part of it?
Great question. You don't have to have a special degree, but in order to practice in the federal court system, you do have to get a certificate.
So any lawyer could say they're ADA.
Any lawyer can say, as long as they are allowed. See, and that's another great point, Jeremy, because what I fear is what some of these attorneys, they're not even, because you have to get a certificate so that you can, we have three levels of, or three different federal courts. We have the Northern District, the Middle District, which, believe it or not, in the Middle District includes Jacksonville, and the Northern District, which is the Panhandle, and then the Southern District, Miami, Broward, Palm Beach, Boca Raton, those areas. You have to get a certificate from that court in order to appear in that court. You don't have to take a test like the Florida bar exam or anything like that, but you actually have to pay your fee. You have to get referral letters from other lawyers who already have certificates that say you're of good character, and you have to be able, you have to be you have to click off the box that says you're very aware of the federal rules of civil procedure and you know what you're doing, which is the only right thing to do in my opinion anyways. I think that's perfectly appropriate. But I fear, Jeremy, that you're exactly right, that some of these lawyers who don't even have certificates to appear are just telling these folks, look, take the path of least resistance, pay this money to this attorney.
And it's a lawyer that's good. They've trusted. They've done so. So there's nothing wrong with it, but he's advising on that, not knowing the skill of what you can do or what can be done. And you don't have to settle. You don't have to pay that. You can actually walk away with maybe paying your lawyer, and that's about it.
I mean, if Walmart called me up, and I definitely have had, franchises of national chains who've come to my office and have hired me. And, the advice that you have to give to them is a lot different than, like you said, the small breakfast restaurant.
Yeah. Because they're not going to be required to change their entire bathroom.
That is correct.
But Walmart would probably say, hey, need to step it up.
Yeah, they would probably settle, right?
I would Walmart would make the changes.
Yeah, they would just make the changes. They'd settle and make the changes, I would think, at least.
The funny part about it is, particularly in this area, they don't get sued.
Why do you think that is?
Because their lawyers will fight tooth and nail. And their lawyers will know what the Americans with Disabilities Act requires, and they will see to it that within 60 days, the case is moot and has no meat on the bone anymore and has to be dismissed. That's why. They never go after the large companies. I mean...
Too many lawyers, too big a fight.
I can tell you right now, I don't think NASCAR's been sued for ADA violations because they would fight it tooth and nail.
Right.
And I wouldn't blame them.
But to go after Susie Cream Cheese's pizza shop isn't that hard.
Right. Because now they're like, well, now I have to, pay my attorney, to defend the case because lawyers are required to charge to defend cases. And then on top of it, they're worried that they're going to lose, and then they're going to have to pay a bunch of money to the plaintiff attorney and then make all these changes that the ADA does simply not require them to make. The plaintiff attorney has to bring in an expert to say that these changes are readily achievable.
Yeah.
And they don't do it. They don't hire those experts.
And what do they consider readily achievable?
Well, it's based on, it's a great question. It's based on the income of the business and essentially what they have in the bank account and what changes need to be made to bring the building up to Americans with Disabilities Act standards. In other words, like I said, if the business has $5,000, $10,000, $15,000 at the most in their bank account, and according to, the plaintiff's expert, you got all these changes that need to be made, well, they need to bring in somebody who can actually say, this is how much it's going to cost.
Okay.
To make
you bring a
changes.
general contractor in and you
got to bring in these experts. And they don't do it. But you have to do it.
Yeah.
Because, you're not suing Walmart. Because no one's going to say, it's sue Walmart and say, they have to prove that these changes are readily achievable. Walmart can make all those changes. It's all readily achievable. It's very simple. And they do. Yeah. And quite honestly, those businesses have excellent ADA reputations. Yep. I mean, they really do.
Oh, they follow it to a T.
They follow it to a T. Absolutely. But once again, the standard that would apply to a Walmart absolutely doesn't apply to the local businesses here that are being sued. They are not required to bankrupt their companies in order to become ADA compliant. That's what's called readily achievable. In order for it to be readily achievable, it has to be within their budget. For instance, if a business doesn't have a plastic sign with Braille that shows where the handicap bathroom is, I mean, that's readily achievable.
Yeah, get that on Amazon.
That's really achievable.
$14.95.
If the sink doesn't have flappers, to turn the water on and off, that's also a $15 Amazon fix or a Home Depot fix. I mean, these things are readily achievable.
But to go knock down walls and take out this is not readily achievable for a small shop doing $1,000 a day.
Right.
Well, I worked with a company, and we're probably going back 8-9 years at this point, but we had to make all these ADA changes, and it came to paving the parking lot, putting full handicap spaces in. I remember when we were redoing the bathroom, the way it had to be set up, the men's room had to be where the women's room was, and the women's room had to be where the men's was, because it had to be this certain size to get the wheelchair around. And the amount of change, that was a couple $100,000 in just changes. And luckily the business had it at that point. But
correct.
If you look at some of these smaller ones,
there's
no way they would be able to afford that. I mean, you're out of business at that point.
Right. But if they quickly enter into these settlements, they don't even hire a defense attorney, or they hire the wrong defense attorney who pushes them to settle. Guess what? You're making all those changes, which means you're probably shutting down.
Yeah, you're going to bankrupt yourself.
Because you will bankrupt the company. And then you file for bankruptcy so that the ADA lawsuit stops in its tracks.
Yeah.
So your livelihood business that you spent 20, 25, 30 years building up, poof, gone. When it didn't need to be. And the ADA didn't require it to be. Okay, Congress didn't develop the ADA to put small businesses out of business, or to bankrupt them. Of course not. It wasn't meant. It was never meant that way, and the law doesn't require it. So
now, if you have like one plaintiff making multiple accusations, what do they get out of it? Like, are they the Superman for disabled people? Are they just trying to? Is it in good sense as to where they, I want all of this to be ADA compliant. This is a good thing. I just want people like me to be able to have free roam. And is it a good thing, or is it in a negative aspect to where it's, let's get them.
I think, I don't want to paint a broad pink stroke over it, all of these plaintiffs, because each one of them have different reasons for doing it. Some genuinely want to be the superhero.
Yeah,
they really do. They want to be a superhero championing rights for those who have physical disabilities, which is fine. Some of them are simply what the federal courts refer to as testers. And they go around to business after business after business after business, looking for businesses that are not entirely ADA compliant. And they're doing it just to locate businesses which they believe in some way discriminate against those with physical disabilities. And then they they have these small group of lawyers who are bringing all of these lawsuits. And these small group of lawyers who are bringing these lawsuits are doing very well financially for doing it. Mm-hmm. And strangely enough, every time I've ever asked one of them how much money they've donated to causes, non-for-profits, it is always across the board, I have not donated a red cent to the cause, which that I have a bigger problem with than someone who has a physical disability who wants to make sure that other people with physical disabilities can enjoy, the restaurant or the hair salon,
just like everyone else can,
like everybody else can.
Jason, so what's your success rate on this, on the ADA cases?
Well, I don't want to jinx myself, but it's about 100%.
So they come to you, this is what I'm having, and 100% of the time,
they don't pay.
We're good. Here's this.
They don't pay.
You get your fee. They don't pay the other lawyer, correct?
They do not pay the other lawyer.
And they pay you for representing them and getting this case basically dropped.
And sometimes they get, I don't blame them. I don't want to mention names, of course, but they get a little frustrated because they paid us all this money. And as soon as the plaintiff attorney knew that it was the Harr Law Firm, they just dropped the case because they knew what they were in for.
Yeah, they didn't even want to go any further.
And so they're not even going to bother. They're just going to go after.
Can I ask something like, what does this cost if I can get it? I'm sure our listeners I know it's different. It changes. And I don't want to get personal to cost.
Yeah.
But are we talking $2,000, $10,000? I have to pay $30,000 up front to something like this. But if my restaurant's not ADA compliant and I'm getting what am I looking for up front? Am I looking for $200,000 to get out of this?
No,
I'm bankrupt me as it is there.
Not even close. The good news is the folks up in Tallahassee make sure all lawyers do not charge excessive fees. So that's a very important rule. And
so you have a certain amount you can charge.
We have a certain amount we can charge. Sometimes, we feel bad because as soon as the plaintiff attorney knows it's us, they immediately drop the lawsuit. We have to actually try to give, we have to give back some of the money because, we just didn't earn it.
It was a phone call. Well,
that's nice.
Wait,
that though.
Wait. So
if you sort of have to.
You call
I've
law
never heard a
firm.
lawyer say that.
Wait. Hold on. I got to get it out of this. So I pay you X amount of dollars. You call the other law firm, be like, hey, listen, I'm representing the case this. And they're like, all right, we're dropping it.
No, I file a motion to dismiss typically. I file a motion to dismiss, and then I let the other lawyer know because under the federal rules of civil procedure, which, like I said, if you're practicing in the Middle District, you better know them backwards and forwards. There's a Rule 11. And what Rule 11 requires is that an attorney, before bringing a case, conduct a sufficient pre-suit investigation to make sure that the case has merit. Well, I'll write, and then what you do is the defense attorney is you write them that letter warning them, if you do not drop this case, we are going to pursue sanctions not only against your client, but against you.
For basically wasting the court's time and not checking out the things.
For not doing a sufficient pre-suit investigation that is required.
And they're like, you know what, I'm not going to do this, and then they just drop.
Because they're not interested
right.
in fighting these lawsuits. They just aren't. They're not interested in fighting. They're looking, unfortunately, most of them are just looking for the business. And believe me, I've heard them say to business owners, oh, look, don't hire a defense attorney because all it's going to do is run up my bill, you're going to pay a defense attorney a bunch, and you're going to lose, as if they are somehow clairvoyant.
Right.
And can predict what the federal judge may or may not decide. So it really behooves anyone who's being sued locally to reach out to a law firm that has a tremendous amount of experience, like the Harr Law Firm.
When you say locally, is Florida locally?
Yes.
So anywhere in Florida?
Anywhere in Florida.
Okay. So not just Volusia, not just Pasco, anywhere in Florida, you can call Harr Law Firm and you could represent them.
Absolutely. You call from Key West, no problem. You call from Pensacola, no problem. Because I'm licensed in all three, the northern, middle, and southern districts. So I can represent businesses in any part of the state of Florida. And so that is a tremendous advantage for people. There's also a lot of different rules because each one of them have their own set of local rules and you have to know them backwards and forwards.
Now, is it, out of curiosity, is it the same for Georgia, Alabama? I know you may not know of it, but is it more or less the same? The ADA law is more or less the same. So if one of our listeners is listening from Georgia and says, well, I'm not in Florida, my restaurant's not in Florida, can't call the guy. But the guy seems to know what he's talking about. How would they go about that?
That's a great question. And here's how that works. Obviously, we're talking about a federal cause of action, the Americans with Disabilities Act, which means the same provisions that apply in Florida apply in Hawaii, in Alaska, in Montana, South Dakota, North Dakota. It's the same law in all the 50 states.
All 50 states.
Yeah, it's a federal law. So it applies equally in all 50 states. So at that point, what a lawyer like someone like me who isn't licensed to practice law in Georgia is I can ask the court to allow me to appear what's called in Latin pro hoc vice, which means just, this one time I'm an out-of-state lawyer, I don't have a Georgia license, but here's my history with
and they can grant you that because you're an expert in that area and what you've done?
Well, because they believe that you can provide a quality defense for that business.
Have you done any of those?
No, but I've been contacted by a lawyer in Georgia who asked about my system. He had actually heard about it for beating these lawsuits. I didn't ever heard of the guy. And he just called me up out of the clear blue. I didn't even know why he was calling.
Would you help him? Or could he hire you?
Well, that's what I told him to do. I said, I'm willing to go in and as co-defense attorney.
Right, and you could do that co-defense. Yeah. So a Georgia lawyer could call you and be like, let's co-defense together. And you're fine because you're working with a Georgia lawyer who has the right to work in the state of Georgia.
In that federal court.
Federal court. Because he's got his gold, silver, bronze certificates just like you have yours. Gotcha.
Exactly. And all he was interested in was just me putting on my professor hat and teaching him my system.
Maybe you need to start a course.
And I said,
start a course.
With all due respect, I appreciate your optimism in calling me, but
I give the guy credit though.
That dog won't hunt.
But I give the guy credit for picking up the phone, Jason. Think about it. He picked up the phone and wanted your secret recipe.
put in thousands of hours to develop this because I wanted to help protect the local businesses around here. And it works. It works.
And I mean, like you said, you can't give him, you got to give him credit. You miss every shot you don't take. I mean, why not?
I just didn't know who he was. I mean, I just never, it's not like he had ever called me on another matter or he had referred me a case or I had referred him a case or anything like that. Or, you know, that we ever broke bread together. Like none of that. Like I literally had no idea. And he wanted me to just drop what I was doing and teach him my system.
I need to know all your knowledge right now.
I was like, wow.
Absolutely. $10,000 an hour. I'm in.
Yeah,
what do you
I
want to do?
mean, you know.
Now, Jason, if a restaurant gets sued for this and you get them, you know, I wouldn't say out of it, but show them that this is, what's the terminology you use?
Readily achievable.
What stops them from getting sued again? Or they just have to keep calling you over and over again? Or is it something that they can't get sued again? Because you're proving that it's not readily achievable.
Well, you know, the interesting thing about this is, to my best knowledge, every business that I've ever represented, which of course we fought every single one, never got sued again for ADA violations. Now, they may have been sued for like a workers' comp claim, you know, somebody
but
slipped
not
and
for
fell.
ADA. Like somebody come in 3 months later.
Nobody ever sued him because the public record showed that this particular business fought this lawsuit. Millions for defense, not a penny for tribute.
And they're like, we're not going to do that again.
So in the end, of course, the money that they paid us is a lot less than what they would have to pay the plaintiff attorney, not to mention completely remodel their building. I mean, I've had businesses that got sued that hired me where the plaintiff claimed somehow that there were problems with the restrooms, and it clearly says on the front door, no public restrooms. Yet somehow they went in there and found all these ADA violations when there were no public restrooms to begin with, just a bathroom in the back for employees. I mean, I don't understand, you know, how that works.
They're just trying to get a quick buck. Like they're just, you know.
Go
on Google, like you said.
Without mentioning names, I mean, I had represented, you know, an adult store, and they were complaining that the dressing room wasn't big enough for the wheelchair to go in there and try on the outfits. And I said, you do see the sign up there that says, we don't let you try on these outfits, and then put them back on the shelf. Not for nothing.
Did you visit that place?
Not for nothing.
Did you visit that place directly?
No, they came to me.
I was going to say, you got to do the research.
I'd have been like meeting at your place, not mine.
I mean, we've represented businesses absolutely across the spectrum. And once again, to every single one of them, have zero interest in discriminating against anybody for any reason. They you know, their hearts are in the right place. Just unfortunately, the strategy that they're being given in most instances isn't very good.
Yeah.
And I'm not here to, you know, it's not my responsibility to judge what other lawyers do, and I don't do that.
No.
No, but you don't take your car to your brother to get fixed. You take it to your mechanic.
That is correct.
You don't go grocery shopping at 7-Eleven. You go grocery shopping at Publix.
Right.
So if you're going to have this, go to somebody or an expert that knows this, not your local lawyer. Nothing wrong with your local lawyer or your guy that does contracts, but he may not know ADA.
Well, it's the
he
same.
He can practice it from what it sounds like, but it doesn't mean he knows it.
Yeah. It's the same thing like going to a car dealership and saying, you know, I'll take this car because it's the cheapest. Well, guess what? When you get on I-4, you may regret that decision because you didn't concern yourself with safety at all. And that's what I kind of compare it to.
Nope.
I said, you know, don't go to a Mercedes dealer shop with $500 and ask them for a car. They probably won't even give you a cup of coffee. But I mean, the first question.
You can buy a key fob for $100.
Yeah, $500. I don't think you can either. And the thing about that is, I think my recommendation to anybody before they hire an ADA defense attorney is say, how many of these have you actually defended and won? Yeah. Not that you settled, where I get to write a check to you.
I settled 400 of these. That doesn't help.
Yeah, that's not the lawyer you should necessarily hire. That's instead of walking in there and saying, how much is this going to cost me to hire the Harr Law Firm? That's not the question you want to ask. The question you want to ask is, Mr. Harr, how many of these have you tried? How many of you have been successful in? Have you represented a business like mine? And are you willing to go to to show up when the inspections take place and everything, that the whole litigation process? It's a very specific process. It's controlled by the federal judge who dictates the dates and everything like that, which is perfectly the way it should be. And that should be the real question. How many of these have you defended? And how many of you, what is your success rate? Like you asked me, Jeremy, not how many of these have you settled?
I think that it's knowledge. I think people are asking, because I'll be honest, if I went to a lawyer and he said, "Oh, I've settled 38 of these," I'd be like, "All right, well then that's pretty good." He settled 38, so he got out. But settling in this case isn't a good thing.
It can be. It's only going to get you sued again, just like that. Those group of folks who are wonderful people who just want the best for everyone, who we met in New Smyrna Beach the other week. They all, to a person, they all got sued again. They all got sued again for settling. And the worst part about it is, like I said, they have now contractually bound themselves to become 100% ADA compliant. Take down the load-bearing walls. Go ahead and do it. Hire the architect. Go ahead and do it. Hire the engineer, the civil engineer. Go ahead and do it because you agreed to do it. And that is the detriment. And that is the major detriment to settling. Particularly, if you ever sign a settlement, I mean, you need to have a lawyer review that anyways. I mean, you should pay a lawyer to review any settlement agreement in any case.
Right. Absolutely.
I mean, that's just common sense to me.
Nope.
If I was involved in a settlement, I'd do the same thing. I'd have a lawyer other than me look at it. And I'd pay that lawyer good money to look at that settlement, so I'm not looking at it in biased eyes because it involves me. And that's what I think you should do. And I think, when I see those things and I see these agreements and they bring them to me, I'm like, unfortunately, with me, I tell you whether it's good or bad. I mean, I don't sugarcoat anything for anybody. And I'll say, unfortunately, this is what you've now agreed to do. And like I said, that happened the other day. And, the guy basically said, I'll take my chances and go in front of the federal judge, which is just, I hated to hear that. And I felt horrible. But there was nothing I could do to help him.
Yep.
There was nothing I could do. At that point, it had gone too far down the road where I could help them. I mean, I met somebody who settled one of these 24 hours before I met those folks down in New Smyrna Beach, and they realized, oh my gosh, what have we done?
What a mistake.
What a mistake.
I hate to cut it short because I actually have more questions and we'll get to off air, but we're getting to the end, and at the end of our show, we do a segment called Come On, Karen.
Come on, Karen.
Come on, Karen.
Where we talk about 1-star reviews and we kind of reflect on it and talk about what we do. But I think today, I'd want to go a little different, because the lawsuits, I think there's a lot of confusion. Restaurants, bars, any business wants ADA, anyone with a disability, we want you to come to our business. We want to help you. We want you to be a client. We want you there. And we want to do anything we can to make that comfortable for you and make it easily accessible. And, for lawyers that will go after small businesses and literally bankrupt them for something that they'd be happy to change if they just knew. Like, because there's a lot of people that don't know the ADA law that would put a handrail, grab bar in, would do all this at a low cost because they would want to do that. Yeah. They just don't know. And now you have lawyers coming after them and literally bankrupt them. Please, businesses, call a lawyer like the Harr Firm that has dealt with this before and can help you out. Because the last thing we want to see is anyone lose their business for something they didn't know or something that was such an easy fix.
Right. And just like the ADA isn't designed to bankrupt a local business, the Harr Law Firm, what we charge, we're not going to bankrupt you either.
Yeah.
If you have to go on a payment plan, so be it. We never charge a client interest for any reason under the sun. We're not a bank. We're not a lending institution. We don't charge interest. We understand. We're working with local businesses.
That's really cool. So let's just say it's $1,000 and I need to make 4 payments. There's no interest on that.
There's zero interest.
That's really cool.
We would never charge a client interest for any reason.
I'm still paying the $1,000, let's say, but I give you 250. There's no interest on that. Just
there's zero
every
interest
month.
on
Give
that.
me 250 till it's paid, type of thing.
Yeah,
that's awesome.
Yeah, absolutely. I mean, we understand what it means. I'm a local business.
Yep.
And, so we are more than willing to accommodate. We don't expect that every local business is going to be able to come in and say, okay, here's all of it up front. We understand that. But under no certain, we just say, okay, well, what are you able to do? And assuming it's reasonable. I mean, I can't give you a 2-year payment plan.
Can I pay $7 every month for 10 years?
It's got to be a little more than that.
Off like the hospital.
Right.
It's got to be a little more than that. But no, we would never, and we never in our 22-year history as the Harr Law Firm charged any client interest.
So what's the best way? Text, call, email, go on the website? Like, what's the best way if they want to get a hold of you? Someone's listening to the show and says, I have some questions on this. How do we get a hold of you?
There's an outstanding business out there called Resalsys that has also allowed for us to have an AI operator. So if you get served with one of these after hours, you can call and our AI operator will pick it up. And if you say, look, I really do need to speak to a person, it'll forward to my cell phone. And I'll talk to you.
So I can call you at 2 a.m. You're calling me back.
I will call you back at 2 a.m, which is a sad statement on the quality. Statement on the quality of my life.
I'm trying it tonight. I'm calling at 2 a.m.
But you better be sued then. But no, yeah. I mean, the best way is to pick up the phone and call us. I'd like to tell you that I'm sitting behind a desk all day long, but that just simply isn't the truth. When you have an active litigation practice, I mean, I had 2 court hearings today. Wednesdays are typically my busiest court day because that's when the state judges hear short matters. And so, but we always have someone available. If you call at 2 a.m., our AI operator is going to pick it up and, you can either leave your name and say, look, please call me in the morning, or if you feel like you're in a desperate situation, you're not going to sleep, then just call. It'll call forward. Say you need to speak to a human. It'll just call forward to my cell phone.
Awesome.
And, you'll be taken care of.
That's great. Yeah, I appreciate you coming on the show.
Oh, I appreciate you guys inviting me. I mean, this is just an amazing experience for me. Thank you so much.
Thank you for what you do. Thank you for helping out a lot of the small businesses. I know in New Smyrna when you met with everybody.
They got flooded with these lawsuits.
No, thank you so much for even just going up and speaking to these small businesses and giving them some advice and, a way out for the ones that haven't settled yet. And, thank you for doing that because, that you didn't have to take time out of your own schedule to go down and do that.
It's my absolute pleasure. And like I said, when you go speak to a lawyer for the first time about these, find out how many of these cases the lawyer has handled and not told their client to settle.
We already know the lawyer we're calling and how many cases he's settled. One, we already know.
Yeah, I mean, if the lawyer says I've settled every single one of them, I'd probably walk out of that office.
Well, thank you very much. And thank you all for tuning in. Remember to check us out on Instagram, Twitter, YouTube, Facebook, Instagram,
X,
Spotify, X. Well, I don't know. I messed
you were
that
all
one
over
up
the
today.
board today. Jeez.
Yeah.
Check us out on all the social media.
Was it Instagram twice? I thought I said Facebook.
No, I said Instagram twice.
Facebook. But we'll see you next week, y'all. Thank you.
This episode brought to you by Stir Hospitality.
Go to stirhospitality.com if you are a new restaurant. If you're a restaurant that is not seeing the profits that you used to.
Bar and nightclub.
Bar and nightclub too. They will get you back in the black. Stirhospitality.com.